I'm former prosecutor Neil Schaus. I'm here with former police officer Michael Scafidi. We're now both criminal defense attorneys. And Mike, I want to talk today about this crime of possession for sale of a controlled substance in Health and Safety Code section 11351. And it's so important because when somebody gets charged with possession for sales, the stakes are so much greater than when it's for personal use, right? Because they don't qualify for diversion, they don't qualify for Prop 36, PC 1000. They're looking at years in state prison potentially. So it's big stakes. And what I want to ask you first is, how do the police and how would the prosecutor determine if drugs were possessed for the purpose of sale versus personal use?
Well, typically here in California, what they're looking at is the quantity of drug, how it's packaged, where it's located. They're also looking for the prior conduct of an individual. They're going to take all those factors into consideration. For example, is there scales in the home or in the vehicle? Is there glassine bags? Do they have hundreds and thousands of bags? Is there a large quantity of the substance? Something of an amount that you wouldn't consider someone who has a habit or is addicted to, let's say, heroin or speed or cocaine would use for personal use. Those are the things typically a prosecutor and the investigating officers are looking for to determine between sales, possession for sales, or simple possession.
So, I mean, they will assume that if somebody has just a small quantity of cocaine, for example, and one bindle, that's personal use. But let's say they have, sort of 10 bindles, each with a quarter gram inside, and maybe they have a bunch of cash, 10s and 20s and 5s in their pocket. Then they'll assume in that situation that, well, it looks more like it's possession for sales.
Oh, I agree with that. And you raise a very good point about currency, having money. Typically, they'll see that if someone is dealing drugs, at least in their mind, that there'll be an exchange of money for those drugs. One thing I will say is my experience here in California is that the police are always looking to make it a possession for sales case.
They want to put the biggest case on you they can.
They do. They want to put the hammer down on you.
So you have 2 or 3 bindles and suddenly they're charging you with sales. They want to see everything as sales versus personal use.
I have actually personally seen people arrested for possession for sale with 1 bindle of a controlled substance, but there were other empty plastic baggies and there's a scale. And they have different denominations of money on them. So they just figure, well, I got there at the end of the sales day, so to speak. So the police are always, listen, in these situations, the cops are super aggressive, which causes them to make many mistakes that help us defend these cases once they get to court.
And it's really crazy because someone who just has drugs for their own use, they can have a big quantity. That sometimes they get it from their dealer in several bindles or several baggies of cocaine or meth or several balloons of heroin. That's how it's packaged when they buy it. I mean, it's ultimately the prosecutor still has to prove in court beyond a reasonable doubt that it was possessed for sales. And even though the police may arrest him for possession for sale, that doesn't mean that can be proven in court.
Oh, I agree with that 100%. In fact, having them show possession for actual sales and the quantity enough for sales is an important component of our 4-point strategy to defend these cases.
Let me ask you about that, because, I mean, we've had a lot of success over the years in defending clients who are charged with possession for sale of drugs and getting those charges reduced or dismissed. Tell me about your strategy. How do you go about defending a case like that?
4 points, Neil. First of all, legal issues. The cops oftentimes, more often than not, conduct illegal searches of our clients, whether it's of their person, their cars, or their homes.
So that they don't have a warrant, they don't have probable cause, or maybe the warrant's defective, but they don't really sort of dot the I's and cross the T's.
Exactly. Sometimes when they have information, the warrant goes stale. The information is old. And we attack that through a Fourth Amendment motion. And when we're successful on that, the evidence is thrown out of court. The prosecution is left with nothing for the prosecution to use in court, and the case is dismissed.
And that's really a best case scenario because, I mean, you show illegal search and seizure, improper police conduct, the case is just gone.
Exactly. The minute you're able to prove to a prosecutor in negotiations or to the court during a formal, what we call a motion to suppress here in California, the case is over with. They have nothing to proceed on. Number two is they have to prove that our client actually possessed the drugs. If they can't prove that our client had dominion control of the substance, then he certainly can't prove that he had possession for sales.
So maybe they search a warrant at his house and they find a bunch of heroin or ecstasy at the house, but maybe he's got roommates, he's got a wife. There's people in and out of that house all the time who had access to that location. I mean, it's not enough that it was at our client's house. They have to prove in court beyond a reasonable doubt that it belonged to our client.
Absolutely. And I don't want to seem like I'm just completely harping on police misconduct or police poor investigative techniques, but the truth of the matter is we see that all the time. They have a bunch of drugs they confiscate, scales, and yet they never fingerprint to see if our client's fingerprints are on the substance, on the bags, on the money, on the scales.
They just rush to judgment. They assume that this person was found near the drugs or this person lives there. We're gonna bust him.
Absolutely. They just rush to judgment. It's almost as if they lose all sense of peripheral view in the basic evidence gathering that most officers are taught in law enforcement academies.
And as a defense lawyer, you're going to call them on it.
As a defense lawyer, I'm absolutely going to call them on it every time. Number three, and we touched on this briefly previously, is they have to prove that the drugs that are being possessed purportedly by our client are for sale and not for typical personal use. And they run into all sorts of problems proving that.
And that's such an important point, Mike, because let's say our client's charged with possession for sale. We take the case to trial. We argue that there's just not enough evidence that it was possessed for sale. And let's say the jury convicts our client, but only convicts him of simple possession for personal use, which is a lesser offense. In that case, our client can do diversion, never go to jail, and ultimately get the case dismissed. Whereas if he gets convicted of possession for sale, we're looking at possibly years in state prison. So, if we can get it reduced to personal possession, either through negotiations with the prosecutor or, by winning that point at trial, it's a great benefit for the client.
Oh, I agree. And whenever you're evaluating these cases, as a lawyer, you want to win for your client. This person, you want to help them. Mm-hmm. And you're always looking for that legal issue first because that's the best dispositive way for your client. And our clients. Then you're looking at these factual issues, you're trying to negotiate with the prosecutor to get something that's divertible. Because in the end, if the client successfully completes the diversion programs, here in California we have PC 1000, as you know, we have Prop 36, which is an 18-month program. Mm-hmm. And the great part about those programs, if the client successfully passes those, completes them, does well, the underlying criminal action is dismissed like it never happened. Mm-hmm. So that's great. And also, you can get it post-conviction. If you do go to trial on a possession for sales case and the jury comes back with just simple possession, the judge has in his or her broad discretion the ability to divert our client under PC, or in that case, normally it would be Prop 36.
Now finally, the issue of mitigation. So, like you said, first objective, try to get it thrown out, illegal search and seizure. Second objective, try to show it didn't belong to our client, we didn't know about it. Third objective is try to get it reduced from possession for sale to simple possession. And finally, failing all that is mitigation.
That's correct. And what we mean by mitigation in that circumstance, Neil, is here in California, we want to show the DA that there's some special circumstances particular to our client that warrants either a reduction in that possession for sales charge down to a simple possession so he can be diverted. Or if their case is strong, there's something about our client's past life and mitigating factors. Let's say they have a bad drug problem or a bad substance abuse problem, or they're now 40 years old and this is their first time they've been arrested.
They have a family to support. They've got children.
Exactly.
Sending them to prison is just going to be a hardship on everybody.
Exactly. And so the mitigation factor in those circumstances could be probation with no jail time, work release, electronic monitoring, something that allows our client not to be torn from his family who desperately need him or her for support so that he doesn't lose his job, which, as you know, in this horrible economy, it's virtually impossible to re-enter the workforce. It's a way to say to someone, we're going to give you a chance because you've done certain good things in your life. So our fourth component is always mitigation, mitigation, mitigation.
And between one of these four defense strategies, it's often possible to get charges reduced or even dismissed, and quite often to keep our client out of jail.
Absolutely. In fact, we've been very successful here in California with this, employing this strategy, this four-prong approach to get the best results for our clients.